A property manager may not require a tenant with children to pay for a pool barrier. Facts. A property management company has a swimming pool barrier policy for tenants with children. This policy requires tenants with children to install a fence or otherwise comply with swimming pool barrier laws. Furthermore, at the termination of the tenancy, the tenant is required to remove the fence or other improvements at the tenant's expense. Issue. Is this policy in compliance with fair housing laws? Answer. No. Discussion. Familial status, including tenants with children, is a protected class under fair housing laws. If the property management company has a policy that places conditions or restrictions upon the rental because of familial status, e.g., compliance with swimming pool barrier laws, the property management company has probably committed a discriminatory act under the fair housing laws. CARS, Para 41, 1491.01. A property manager must disburse funds as directed by the parties. Note: a lease owner is not permitted to demand or receive security, including prepaid rent, in an amount in excess of 1 1/2 months' rent. However, a tenant is not prohibited from voluntarily paying more than 1/2 month's rent in advance. A property manager should wait until the end of a tenancy before returning the security deposit, unless the landlord agrees otherwise. Facts. The broker represents the owner of residential real property. On September 4, 2011, a notice of trustees sale was posted on the rental. On October 6, 2011, the broker sent the owner a notice of termination of the management agreement along with an owner's authorization for refund of security deposit, which provides for the return of the security deposit to the tenant. Despite these efforts, the broker has been unable to contact the owner. In addition, the tenant has informed the broker of the tenant's plans to move out of the property prior to the trustee's sale, scheduled for December 23, 2011, and has requested a return of the security deposit. Issue. Can the broker refund the tenant's deposit now? Answer. No. Discussion. There is a difference between terminating the property management agreement, because a notice of trustee's sale is received, and being able to refund a deposit, because of an actual trustee's sale. More specifically, the broker is free to terminate its relationship with the owner. However, pursuant to lines 33 to 34 of the AAR Property Management Agreement, only upon the actual trustee's sale is it permissible for the broker to return the deposit. Thus, the broker should not refund the security deposit unless the owner approves of the request. Addenda are part of the lease. Facts. Broker A was the property manager for a property on Elm Street, the property. Broker A signed the lease on behalf of the owner. Broker A used addendums 1 and 2, the addendums, in every lease he signed as a property manager. Broker A drafted the addendums and therefore did not give a copy of the addendums to the owner because he believed they were proprietary. The owner hired Broker B to list and sell the property. Broker B could not provide a copy of the addendums to the buyer because Broker A refuses to provide those addendums unless the buyer purchases them. Issue. Can Broker A refuse to give a copy of the addendums to the landlord or buyer? Answer. No. Discussion. AAC. R4 28202. Upon execution of any transaction document, a salesperson or broker shall, as soon as practical, deliver a legible copy of the signed document and final agreement to each party signing the document. Therefore, Broker A, as the property manager, must provide the owner a copy of each fully executed lease, including all addenda. Thereafter, the owner can then provide a copy of the full lease to the buyer. Arizona Residential Landlord and Tenant Act has a fire exception. Facts. A tenant in northern Arizona volunteered to pay rent 6 months in advance. However, she is nervous about losing her prepaid rent because of a local wildfire. The tenant asked about additional language being added to the lease to protect her. Issue. Answer. Yes. Discussion. Pursuant to ARS. Paragraph 33, 1366. A. If the dwelling is damaged or destroyed by fire, to an extent that enjoyment of the dwelling, is substantially impaired, the tenant may do either of the following. 1. Immediately vacate the premises and notify the landlord in writing within 14 days of his intention to terminate the rental agreement, in which case the rental agreement terminates as of the date of vacating. 2. If continued occupancy is lawful, vacate any part of the dwelling unit rendered unusable by the fire, in which case the tenant's liability for rent is reduced in proportion to the diminution in the fair rental value of the dwelling. B. If the rental agreement is terminated, the landlord shall return all security recoverable under Paragraph 33, 11321. Accounting for rent in the event of termination or apportionment is to occur as of the date the tenant vacates all or part of the dwelling. Therefore, no further language is needed in the lease, and the landlord would be obligated to return the prepaid rent, subject to Paragraph 33, 1321, in the event the dwelling is lost to fire. Broker, licensee security deposits in trust account. Likely. Commingling facts: a brokerage has a property management division and manages 300 properties. Licensees John, Jill, and Joe have their license with the brokerage, and they personally own rentals that are managed by the brokerage. The brokerage has one trust account to hold all of the security deposits and rent for the 300 rentals. Issue: may the brokerage hold the security deposit or other funds on behalf of John, Jill, and Joe in the brokerage's trust account? Answer: no. Discussion: in Arizona, under the laws of the agency, a licensee is viewed as the same person as the broker. Therefore, if the brokerage holds John, Jill, and Joe's funds in the trust account, the brokerage has likely commingled funds. Facts: in light of significant credit problems, the tenants offered to pay a full year's rent in advance if the landlord would accept them as tenants. The landlord ultimately accepted, and the parties entered into an AAR residential lease agreement. The tenants took possession and paid the entire year's rent in advance. Issue: is the property manager required to hold the rent in the brokerage trust account to pay the landlord on a monthly basis? Answer: see discussion. Discussion: based on the facts presented, the parties agreed in the lease that the full year's rent would be paid to the landlord. Accordingly, there is no obligation for the property manager to maintain the rent in the brokerage trust account. Rather, the rent should be forwarded to the landlord as the parties agreed.